Turn to the third case on this morning's docket. Case number 103785, State of Kansas v. Corky A. Williams.
May it please the Court, Michael Whalen on behalf of the appellant Corky Williams, and with Your Honor's permission, I'd ask to reserve 5 minutes for rebuttal.
5 minutes is granted.
Thank you, Your Honor. The Sixth Amendment requires notice and information to a defendant about what it is he's being charged with and what he has to face. This court in Stafford back in December basically said in determining what a crime is and how it should be assessed, one takes a look at the actus reus, the mens rea, or other distinct material elements of a crime. Aid and abet is a separate and distinct crime.
Is that contrary to a long line of our cases where we have said it is not a separate crime?
Times have changed, and if we go back to 1976, we compare KSA, I believe it was 62-2110, which was the original aid and abet statute. That statute said specifically that a person who aids and abets can be charged, tried, convicted in the same manner as as the principal. The legislature made a change then, and if we still presume the legislature does not make pointless legislation, the legislation was changed to that basically just a theory of liability, that one who aids and abets can be held responsible the same as the principal. They took out the language that said can be charged, convicted, same as the principal. The language was changed. And yes, it does fly in the face of, 30, 40, 50 years of decisions in this court. But we've had a re-stress analysis on alternative means as of late. And if we look at this for what it is, a separate and distinct crime, because when we distinguish crimes in Kansas, and this court in Stafford, what do we look at? Is there a distinct actus reus? Is there a separate act that the aider and abetter must perform that is separate from that of the principal? Well, of course, they must aid and abet. They are not acting as the principal. Their actions are completely separate and distinct, such as Mr. Williams driving a vehicle but not being present at the time of the shooting. Is there a separate mens rea? Yes. The specific intent to assist in whatever it is going on. And under Overstreet, this court even more pinpointed that requirement in first-degree murder cases on aid and abet, that the individual must have the specific intent and premeditation to assist in the premeditated act. So over the years, and I think in this context in particular, in that of first-degree murder aid and abet, this court has defined what must be found. And what we lack with aid and abet, and in particular, it becomes very telling when we get to jury instructions. The jury instruction is basically the same as what the statute says. One who aids and abets, yada yada. But it doesn't address the fact that the individual must, that there's an element of action. It does not state that there is an element of specific intent. All of which are there. If we take the analyses of this court recently in so many choices. But if we look at, say, an alternative means approach under the rape statute, this court has found penetration is the actus reus. Whether it's finger, object, or otherwise, that's not an alternative means. That's just achieving the same action. Here, we have a completely separate and distinct action and thought process that does not match that of the principal and having been charged as such. And it is not defined that way by PIC or in the jury instructions when they're given to a jury. Now, we're talking about there then the next step into due process fair trial rights of the defendant, of juror confusion and an assurance of jury unanimity in a conviction for first-degree murder.
Isn't part of the problem with that, though, that a principal can have done the same types of actions leading up to a murder, perhaps? They could have been discussing or planning. So there really doesn't necessarily have to be a separate actus reus for a different action by the aider from whatever the principal might be doing as well.
Now, I disagree, Your Honor, because the principal will have killed somebody.
And they may have done
better not.
It would be overlapping. Let's say it that way. So how do you distinguish it?
So. While he might be involved in planning or driving the vehicle to get there, the person that is committing the murder is still the person committing the murder, separate and distinct from aid and abet.
But the criminal violation is not driving a car. The criminal violation is the killing, and isn't that what we focus on?
The criminal violation is the assistance to the killing.
But there would be nothing without the killing.
Right, this would be a lot easier if this person hadn't died. But that's the difference. There was a principal. There was an actor. There was a shooter.
But we cannot hold the aider and abetter liable without that act. So how do we separate that? The crime is the murder.
The crime for the principal is the murder.
The actus reus is the murder. That is the element of the crime that we're focused on.
The actus reus of the aid and abetter is because he cannot be convicted of aid and abet absent a finding of aid and abet. He's held accountable for the act of the principal, for the murder. His action was not the murder. His action was assisting in the murder. Separate and distinct. Mindset. Aid and abet does not, well, after Overstreet, there is a premeditation issue there. But aid and abet, an aggravated burglary. Aggravated burglary, general intent crime. Aid and abet, aggravated burglary, specific intent crime. Different actus reus.
Different mens rea.
I'm sorry, mens rea. I apologize.
So let me clarify, your argument about, excuse me, Overstreet seems to be that the jury instruction that's given doesn't include the specific intent element that we've held there is in Overstreet. But your argument here about alternative means is that there's a different actus reus, not a different mens rea. Is that correct?
Well, it's still...
I guess I'm not understanding where you're pulling in the mens rea issue. What's your argument about that? Is there a different mens rea?
I think it's still the intent to have happen, and that's formed through assisting the person. And the intent is to assist for this act to happen. It's not, if it was, I am premeditating to murder this person, they would be the principal. And there's still a distinguishment about them projecting and assisting this person that I think is separate from the actions of the principal.
It's a different type of specific intent.
Correct. Now, the other thing that I think if we can take a step back from this in big picture a little bit, if we're supposed to interpret criminal statutes in favor towards the eye of the defendant, and what we're trying to create in any trial situation is a fair trial, due process, notice of the crimes, being able to establish defense to those crimes during the course of trial. What is preventing us from doing this? A paragraph of typing by the state. To charge aid and abet takes a paragraph. The state controls the complaint, the information, the charging documents. We aren't talking about any onus at all upon the state of Kansas in prosecuting these cases. None. None. There is no added work involved except to actually give full notice to a defendant when you know, such as this case, that they are not a principal, that they are an aider and abetter, and to charge them with that. Because I think we run into a problem also in not making this distinguishment. In somebody's charged as principal, witness gets on the stand and says, it wasn't him, it wasn't the defendant, it was me, but he drove. So now there's evidence before the court that he was an aider and abetter. Because they're the same thing, you don't have to charge it separately, there aren't different elements. He can now be convicted when his entire defense was based on, I wasn't the principal. By not keeping this as a separate crime alternative means, he can then have it amended, or, like felony murder, first degree murder, and now it's both. And we'll let the jury decide. Without notice, without forethought, without representation by the state or election by the state.
Within your context of your Sixth Amendment argument that you began with, does the state then need to inform the defendant of the particular act that it alleges aided or abetted the enterprise? You were saying there's no onus on the state, but if you're going to say that there's notice here and that it's separate, that it would be akin to the overt act or in other areas that you would have to, if it's a notice thing, then why don't they have to notice what it was that constituted aiding and abetting?
I think that's probably one for this court to decide. As the statute and the instructions stand with it, we don't even.
If you take, my point is, if you take your Sixth Amendment argument of fair notice, and the logical extension is to advise of the act that was aiding and abetting, then there is an onus. There is a great deal more that the state has to do.
The state knew my client was driving a vehicle and never went into the apartment. The state has all the information. The state has unlimited resources by contrast to Board of Indigent Defense Services represented defendants. They have the police, they have large staffs, they actually get budgets. It's still not an onus, I don't believe, Your Honor. But here's the thing, here's the other side. We're not preventing them from charging somebody with both acting as a principal and acting as an aider and abetter. Charge it in the alternative. That's all it takes for the state to cover itself. And then they can elect. And since the state has the burden of proof and evidence and assuring that the defendant gets a fair trial, this is not much to ask. When we have different mens rea, different actus reus. Unless there are other questions on that issue, I would like to speak briefly about closing argument, the prosecutor in this case. The statement was made, premeditation, didn't say, premeditation can happen like that, but it was more like premeditation can happen like that, in half a second, as opposed to an instant or instantaneous. Everybody ought to know that you can't really say that. And I think it goes towards anytime you're trying to define the time limit or that it's instantaneous or nearly instantaneous, this court has repeatedly, as has the Court of Appeals, said don't do it. And to get in there and try and define it that way,
Before
I believe
what?
represents ill will.
Before what? Half second before what?
Before killing somebody. That
Before
premeditation can occur.
the act occurs or the moment of death or?
Let me find the exact quote. I'll pull the exact quote for you, Your Honor, and address that in rebuttal.
No, I'm just saying that you can't say that you can form premeditation in half a second, but half a second before what?
What the prosecutor said here is just a half second before you actually fired the fatal shot.
So I guess that half second.
Is that the focus then? The murderous act, or the actual death, or?
Well, that became the focus of this prosecutor in her presentation, that the half second before discharging the firearm was all you needed for premeditation. So specifically to this case and these facts, yes. She wasn't arguing necessarily going back to the conspiracy, we're going to go through and do this. She made a separate argument apart from the planning and all of that.
But we found that you could have premeditation while you're in the act of manually strangling.
Correct.
And the act has already started. So how do you distinguish that from before the gunshot or the gun is discharged? I mean, that's before the act occurred.
The distinctions in those cases, and I believe State versus Drennan was one, because it was mine that I tried, was that the time of death was estimated for it to occur was 4 to 8 minutes. And so you would have achieved your knowledge of what you were doing, and it became a premeditated act, even if you had started just as trying to restrain the individual. As it went on and they grew more lifeless, then premeditation occurred due to the ongoing of the act. It wasn't half a second. And I think that's a distinguishment between, there is a time element that has to be there, but to say that it is instantaneous or half a second is, I think, forbidden by this word.
And you're saying that there's a separate, I didn't see it, so I'm going to have to go back and look, but you're saying there's a separate argument by the prosecution that premeditation was formed during the act, as opposed to, I mean, because the part I wrote down in my notes was the prosecutor said that this was clearly thought over, what they were about to do before they went to Rhonda Shaw's house. And this was no happenstance. This was something the four individuals thought about as they made their way over to Rhonda Shaw's house. It's the reason they went there. I mean, I realize he said the little thing about the half second, but it doesn't seem to me to be the focus of how they were trying to tag the defendant for the premeditated murder, that this was thought about a long time before, and it just happened to be that he made the unfortunate statement about half a second. You're telling me I go back and look at that closing argument, there's going to be an alternative way to convict this defendant on there.
I
missed it. I
think that's correct, Your Honor.
Okay.
That was part of the argument, but we still came down to, hey, you can form it in a second or half a second.
It seems like the focus of the argument doesn't have anything to do with forming it during a half a second, that they knew what they were doing.
I think, Your Honor, if I may, that was more in response to, I believe it was Mr. Phillips' defense that this was a drug deal gone bad, and he had the gun and was attacked by Mr. Dyer.
Okay, I'll double check my notes.
I mean, just before that half-second statement, what the prosecutor says is, what that means is that they thought it over before they went in and did it. And that fits in with his argument about they've talked about it before they even go to the house.
I think the charge.
And then he refers it back to the instruction. That's what it means, but then he makes the half-second statement.
And I think that goes in line with the fact that this was a conspiracy, that they were also charged with conspiracy. I mean, that did come through in the focus of the case. I'm not denying that.
Any further questions of counsel? Thank you, counsel.
Thank you, Your Honor.
May it please the court, the state appears by Jody Litfin. I guess I can start with the alternative means issue since that's what we began with. It's the state's position here that we really have to look at the Brown case when we start looking at what an alternative means crime is. And if we look at Brown, we start out with, does the statute set out distinct material elements? And the state would submit that there are not distinct material elements of a crime within the aiding and abetting statute. It's not a crime itself. It doesn't set out any criminal action.
But we've said that mere association or presence at the crime is insufficient.
That's true.
And there has to be something else, something that furthered the enterprise. And so the person that's the aider and abetter has to do something more than simply the elements of the crime.
Yes. And they have to have, you've said that they've had to have the specific intent to do the crime and then also that as well.
But
yes.
So I'm having a little trouble understanding why that isn't an additional element, like the overt act or like attempt, has it's the same crime, principal crime, but there are other things that have to be shown to get a conviction on that theory of liability.
Yes. And maybe that's what it goes towards, and maybe that's how we need to look at it. It is a theory of liability. It's not a crime. When I looked at Brown and they're setting out distinct material elements of a crime, here we have the first-degree murder would be the crime, and the alternative means would be a felony murder as opposed to a premeditated murder. If you're looking at the actions of what the principal has done, those would be your alternative means. Those would be your distinct material elements of the crime. For a theory of liability, for aiding and abetting, it doesn't set out, I don't think that falls under a separate distinct material element of the underlying crime that's being charged in every case, which is different.
But if it's attempted first-degree murder, then you add some elements, right?
Yes.
But if you're aiding and abetting and you have to prove something more than the elements of first-degree murder, those elements that must be proved are simply proving the theory of culpability, or
showing how they can be held liable to the same the same amount as the principal. It doesn't add an actual element to the underlying crime.
but it's necessary in order to convict them to have that additional fact or facts.
Yes.
And so why isn't that the functional equivalent of an element if you have to prove it to hold them, to convict them?
I guess I would just have to say that based on the fact that it's a theory of liability and not a crime itself, and it doesn't set out distinct elements of the crime. I guess, as Boyd put it, it's an underlying issue that could be taken up with any crime. So I see the point that you're trying to make, but I just think that we have to distinguish a theory of liability from a statute that sets out an actual crime. If we look at the second prong in Brown and look at whether it describes material elements or factual circumstances that proves the crime, again, there is some case law from the Court of Appeals that says this could set out factual circumstances or could set out describing material elements, how they could be in aiding and abetting. But again, that's a secondary issue and not setting out distinct alternative means or material elements of the crime. Basically, what the state's relying on is the Court of Appeals case law in State versus Snover, which talks about the underlying premise of accomplice liability, how this court has held that aiding and abetting has not needed to be charged, how they've been criminally equally liable. You can be equally liable from the principal or from an aiding and abetting standpoint. And a couple of other cases, State versus Kittman, which also went through the Brown guidelines and stated that there were no alternative material elements to the underlying crime, and State versus Jackson, which also talks about the long history of what our court has held for aiding and abetting and how it doesn't have to be charged and proven separately to be declared equally guilty of that of the principal. Also, if we want to point out too that there are some Washington state law cases that support the notion that principal and accomplice liability are not alternative means. I know this court has referenced Washington state law as of recently to help kind of determine alternative means crimes in the way that we do the analysis there. So if we look at State versus McDonald, that held that accomplice liability and principal liability are not alternative means, and that extending it to theories of liability would go against the longstanding notion that that aiding and abetting or accomplice liability does not have to be charged in order for someone to be held criminally equally liable. I'll move on to the prosecutorial misconduct claim. And although half a second is close to instantaneous, admittedly, I don't think that the prosecutor's statement went as far as calling premeditation something that can be done in an instant or was instantaneous. If we look at his closing argument as a whole, he does state several times that premeditation is to think the matter over beforehand, that the evidence showed that the defendants had thought the matter over beforehand. It doesn't put it really, I don't think he puts it in a specific time period or doesn't make that the focus of the closing argument. He does go through and talk about each element of the crime, what the definition of premeditation is, the evidence that was shown that meets premeditation, and it's an isolated comment. It's in the middle of his closing, and again, I think his closing as a whole is appropriate, and if we look at that in context, it wasn't, the half a second wasn't the focus. Also, I think this case, the facts here are distinguishable from State versus Holmes, which held that it was reversible error there, and in State versus Holmes, there was definite evidence on the record that the prosecutor knew not to say that premeditation was instantaneous. He had talked about it with the trial court and then deliberately said that. So I think that having no evidence here of a deliberate misstatement of the law, it cannot be held to be anything but harmless in this case if it was held to be outside the wide latitude that the prosecutor's given. It was not gross or flagrant, and again, there was strong evidence here for each of the, for Mr. Williams' conviction here, and strong evidence of premeditation, aiding and abetting, and conspiracy.
I'm a little unclear. Are you saying that it was or was not outside the wide latitude?
I'm trying to cover all my bases. So initially I'm saying it was not outside the wide latitude because I think generally he's saying a correct statement of law. Premeditation is to think the matter over beforehand. Half a second is beforehand. He didn't blatantly say it was instantaneous and can be formed in an instant. So my first argument would be that it's a correct statement of law and not outside the wide latitude. And to cover my bases, if it was outside the wide latitude, I'm saying it was harmless for no gross flagrant misconduct. It was not done deliberately, or there's no evidence of purposeful.
So it could be a nanosecond before the act. It's not instantaneous, is what you're saying?
That's pretty close, but he did not use the exact words instantaneous, which I think is what this court has had issue with, or can be formed in an instant.
PIC instruction says not instantaneous, right?
Yes.
I would like to ask you a question about the Batson challenges.
Okay.
In this case, as I understand it, there were 3 African Americans that were a part of the jury pool, and all 3 were struck through peremptory challenges. Isn't that right?
Yes.
And in each case, the defendant raised an objection.
Yes.
And the race-neutral, and there was a sidebar, a race-neutral reason provided for each peremptory challenge. It just seems to me that what qualifies as a race-neutral challenge, working in a facility where one of the witnesses may have had contact, is speculative to say the least. The other, I think, had to do with unpaid traffic tickets, which may lead to an adverse relationship with law enforcement. again, very speculative. There's no inquiry made as to whether there were. And then the last one, I believe, had to do with an inattentive juror. Is breathing the same air as the defendant a race-neutral reason? It just seems to me what is happening here, what clearly happened in this case, was that African Americans were denied their opportunity to serve on the jury for very flimsy race-neutral reasons, completely defeating the purpose of what Batson is designed to protect. I mean, what's your reaction to that? I mean, it just seems to me that's what occurred here.
My reaction to that is that there was a proper challenge by Mr. Williams of these jurors. The state provided, again, an appropriate and proper race-neutral reason, which could be...
Race-neutral reason it seems to me anything. I mean, what is a race-neutral reason? And in this case, I mean, it's could have had contact because I was a supervisor in a kitchen where someone was in the same facility as me. There's no showing that there was contact. There's no showing of anything.
I think
that's about it. Could have lived in the same community, could have had contact. What's the difference?
Well, I think it could have been prejudicial there for the reason why they were at that facility. I mean, it was Topeka Correctional Facility. She could have had a negative connotation to that witness. There could have been some reason...
This is a prosecution witness, right? Not a defense witness.
Correct. Right. It could have been some reason why
Could have been. There's no showing at all. It's just it could have been.
I don't believe there has to be a showing.
I understand.
And it doesn't even have to be persuasive. I think it's a very low bar what the state has to show, and I think that they met that. And I think that once we provided this race-neutral reason, the defense counsel in this case could not come back with any other reason to show it was purposeful, and the district court properly held that he didn't meet his burden. The burden is always back to the defendant.
By eliminating all three minorities, just by that fact and factoring in the I don't know what suspect race-neutral reasons, but anyway, by throwing that in, and that you couldn't see that might lead to a conclusion that this is purposeful.
I don't think the defense counsel asserted anything that showed it was purposeful. I think he simply made his objections or challenges. We provided our reason, and he didn't have anything to add. It appeared to me from the record that I don't know if he made any further argument as to why. And it also could have been the timing of them. Also, he challenged them as each one separately and not in the end together, so he didn't finalize his...
That was going to be my question. Can purposeful discrimination be demonstrated in the collective as opposed to the individual?
I think you could make an argument either way. Like, you could make an argument.
Do you have any authority on that?
I don't believe I do.
Okay. But it does seem to me that the question is different the third time it happens.
Yes.
And if in fact what has occurred is that every African American has been struck.
And I think that would be probably the more appropriate time to make that final argument after you've seen the pattern or seen the purposeful discrimination. But again, I don't think the defense counsel did that in this case. He simply made the challenges. And I think the district court gave the opportunity several times. We might want to, I'll reconsider this at the end of the challenges. We might want to hold off on your challenges. So I think the opportunity was there for the defense counsel to meet his burden, but that he simply didn't raise these arguments. And interestingly enough, one of the defense counsel, I believe it was Kettler's counsel, agreed with the juror who was just not able to pay attention. I think that's a concern for everyone. If you have a juror who's unwilling or unable to pay attention, I think that benefits both sides, no matter what race the juror is, to take that juror off if they're unwilling to participate as a juror. And if there are no further questions, I'd submit the rest of the issues on the briefs.
Do you have any further questions of counsel? Thank you, counsel.
Thank you, Your Honor.
To follow up on the Batson issue, I believe all three co-defendants at the end of jury selection reasserted their challenge to all three African Americans having been struck from the jury panel. And the court reaffirmed its prior rulings and instructed the parties to proceed with that jury.
Seems like there was one defendant, though, whose counsel made specific statements about agreeing with the challenge to the juror that wasn't paying attention and wasn't listening, specifically agreed.
I believe that's correct. I don't recall.
One of the defense
I
counsel.
think that maybe it was Mr. Phillips' counsel. I believe Mr. Williams objected or joined in the objection on all three having been removed. But it's a difficult point. I think prosecutors have learned not to say, well, we got rid of him because he's black. I mean, they weren't paying attention, but I think the point was well made in the brief filed was there were similar complaints about a number of other non-minority Vermeer people.
That
who
point
were
was
not-
made in the brief, but where's the record citation? What specifically does the record establish regarding that?
I couldn't tell you without looking, Your Honor. And I just don't have that in front of me. But in context locally, I mean, it's kind of, you run into the similar problem on habeas petitions. If the attorney made a strategic decision and they get challenged on ineffective assistance of counsel, was it a strategic decision? Yes. Because it's within their bailiwick. There's no means really of looking at it or challenging it as to whether or not, I mean, of course every reason is going to be a race-neutral reason. But when you have a limited panel and there are only three people, and I think that's the point that was made, that there are only three persons of color within the panel and all three of them are gone on pretty slim reasons, that is definitely cause for review and analysis. On the alternative means, I just wanted to give the court the correct citation. It was the earlier Kansas Criminal Code, KSA 62-1016, which read, any person who counsels, aids, or abets in the commission of any offense may be charged, tried, and convicted in the same manner as if he were a principal. That language was changed with the revision of the criminal code to KSA 213205. A person is criminally responsible for a crime committed by another if he intentionally aids, abets, advises, hires, counsels, or procures the other to commit the crime. The language about charging him, trying him, convicting him in the same manner was removed by the legislature. And I know this goes back to 1976, but the rule of statutory construction, if the language is plain and unambiguous, combined with the legislature doesn't make meaningless legislation, they made a definite choice to change the wording and exactly how this statute was to have been applied. And yes, there are separate elements that are required. This court has several times found that aid and abet, a complete defense for aiding and abetting, is voluntary intoxication, because it can deny that specific intent that is required in order to commit the act. And although in the first-degree murder, there is a kind of uber specific intent and inclusion of premeditation, if you put it up against any other general intent crime, I mean, you have different mens rea. And these are how we distinguish crimes one from another in the state of Kansas, and it should be done here. If the court has no further questions, I'll actually be done.
Any further questions of counsel? Thank you, counsel. Thank you both for your arguments this morning. The court will take this matter under advisement. This time the court is in recess for 15 minutes.